My name is Victor Vadas. I'm the Deputy Director of the Academy of European Law, and this is the final episode of the series entitled 30 Years, 30 Cases. In 2022, ERA celebrated the 30th anniversary of its foundation, and for the occasion, we prepared a series of short video podcasts about judgments of the Court of Justice of the European Union and opinions of Advocate General. For each year, we choose a decision or an opinion which turned out to be a milestone in the development of EU law in the given year, and we invited various experts, academics and practitioners to share their opinion with us and the audience. As I mentioned, this one is the final episode of the series, and in the year 2021, we found the most quoted, discussed and disputed judgment of the Court of Justice, the case launched by the European Commission against Poland, C-791/19, the judgment of the Grand Chamber which was announced on the 15th of July 2021. In 2019, after many years of negotiations, the European Commission brought an action before the Court of Justice seeking a declaration that, in adopting a new disciplinary regime applicable to Polish judges, the Polish government has failed to fulfill its obligation under EU law, namely, to provide effective remedy and guarantees of impartiality and independence, the right to a fair process respecting the rights of defense of the accused judges, including a decision in a reasonable time, and the protection of disciplinary proceedings from direct or indirect political influence. It was also assessed by the Grand Chamber if a disciplinary procedure where certain judicial decisions can be classified as disciplinary offences can be used as political control over the judiciary to exert pressure on judges and influence their decisions. Moreover, if judges are exposed to disciplinary proceedings as a result of the fact that they have decided to make a reference for a preliminary ruling to the Court of Justice, their right to put questions to the court and the whole system of preliminary reference orders can also be undermined. To elaborate this judgment, I have invited to speak Adam Bodnar, a constitutional law and human rights law professor, the Dean of the Faculty of Law of the SWPS University Warsaw. In 2015, Mr. Bodnar was appointed as the Polish Ombudsman, and until the end of his term, he promoted fundamental rights in Poland. In 2019, he was awarded the Rule of Law Award conferred by the World Justice Project for this outstanding effort in strengthening the rule of law in difficult circumstances. Professor Bodnar, thank you for accepting our invitation. My first question to you: why this judgment of the Court of Justice is so significant in the development of Polish constitutional law and EU law?
I think this judgment was a breakthrough in relations between Poland and the European Union. For me, this judgment is quite symbolic on many different levels, not only because of its legal significance, but also because of the fact that on the same date I stopped to be the Ombudsman of Poland, because by virtue of the Polish Constitutional Code, exactly on the 15th July 2021, I have to leave the office because of the ruling of the Polish Constitutional Code. But looking more deeply, I think this judgment is a summary of the long battle for the independence of the Polish judiciary. And starting from this judgment, I would say a lot of things have changed in the context of relations between Poland and the EU. Why it is a part of the longer battle? Because, in fact, we should look back into the origins of the conflict into 2015, 2016, when the Polish Constitutional Code has been politically captured. From that moment, we observe a number of changes affecting the rule of law in Poland. And those changes concerned common courts operation of the National Council of Judiciary, and finally, the establishment of the disciplinary mechanism. Moreover, European Union was very active in, I would say, stopping some of those changes, or at least giving warnings to Polish authorities by starting the rule of law procedure under Article 7 of the treaty, or by different political consultations, but foremostly by starting infringement actions. So this judgment of 15th July 2021 was in fact the third infringement case that has been finished by the European Commission, but in fact the most important one. And I think that the importance of this judgment lies in the fact that the whole institutional system of disciplinary responsibility of Polish judges has been put under question, has been declared as being contrary to the EU values. Moreover, the Court of Justice of the EU declared that the disciplinary chamber of the Supreme Court, in a way as it is construed in the operation of the Supreme Court and in the whole operation of the Polish judicial system, is violating rules of the EU concerning right to court, as well as right to effective legal protection as guaranteed by the Article 19 of the Treaty on European Union. And after this judgment, we observed not only financial penalties imposed on Poland, but also the suspension of the payment of money from the EU Recovery Fund. So I would say that after this judgment, there is no way back. Polish authorities cannot say that simply they are of different interpretation, but simply they have sooner or later to comply with judgment, because otherwise they fail to fulfill some basic obligations stemming from the EU membership.
What exactly happened to the judiciary and the rule of law in Poland?
I think that the major attack on the rule of law in Poland happened in 2015 and in 2016, when the Polish Constitutional Code has been politically dominated. So there were a number of legislative but also political actions made in order to create an effective control over how the Constitutional Code is working. And this, I would say it was like the major cause of all later problems, because elimination of any independent judicial review enabled later on Polish authorities, Polish parliament and the ruling majority to adopt different changes affecting prosecutor's office, media law, secret services, as well as operation of courts, in a way to control effectively of what is happening in all those state organs or state bodies. When it comes to judiciary, there were a number of different reforms adopted. The first one included elimination of the procedure under which judges may give opinion to candidates for positions of the presidents of different common courts. So starting from 2017, all presidents of courts could be basically appointed just with the decision of the Minister of Justice, who is at the same time Prosecutor General, who is basically the acting politician. Second action concerned the National Council of Judiciary. National Council of Judiciary is a very important element of the Polish legal system, because the National Council of Judiciary is composed of 15 members who are judges and 10 members who are elected by both chambers of parliament, by Mr. President, and also Minister of Justice, Prosecutor General, President of the Supreme Court, and the President of the Supreme Administrative Court are members of the National Council of Judiciary. But basically, in this mixture of when there are 25 persons, 15 of them are judges, and they were always elected in Poland under the Polish constitution and in accordance with the Polish, let's say, constitutional tradition. All those 15 members were always elected by peers. And the legal change that happened changed the method of electing those members of the National Council of Judiciary. So right now they are elected by the parliament, so the parliamentary majority, and not by peers, not by other judges. And this is like the primordial sin, a cancer in the legal system, one could say, because it means that any appointments later on made by the National Council of Judiciary in this new composition are per se controversial or could be questioned from the point of view of compliance with the with basic human rights, including fundamental rights as they are guaranteed in the EU Charter. And but the third change affected the operation of the Supreme Court. And here we have seen a number of different specific reforms. So one of them was a little bit similar to the, let's say, Hungarian model. That was about decreasing the retirement age for the judges of the Supreme Court, because as a result of this reform, 20 judges of the Supreme Court were asked to leave because their retirement age has been decreased from 70 to 65. And only thanks to the judgment and interim measure by the Court of Justice of the European Union, it was possible to reinstate them or to give them once again a chance to operate in the judiciary. And only thanks to this, the first president of the Supreme Court, Małgorzata Gersdorf, could continue in her term, and she could finish her term in accordance with the Constitution. But another change concerned the operation of the Supreme Court, because two new chambers have been created in the Supreme Court: the Chamber of Extraordinary Control and Public Affairs and the Disciplinary Chamber. And both those chambers were appointed by this National Council of Judiciary in new composition, in a very flawed, in a very controversial procedure. And I think right now nobody has even any doubts that this procedure was highly politically determined. The problem was that this disciplinary chamber was not only politically to great extent nominated, but also this chamber operated, I would say, in certain cooperation with disciplinary judges appointed by the Minister of Justice. So the Minister of Justice became like the major figure in the legal system who had a control over different aspects of the operation of the judiciary. And as a result of this, he could, not he, but people who were dependent on him, who were appointed by him, could influence the operation and activities of different judges in Poland by starting disciplinary cases against them, by targeting them, by intimidating them with different kinds of legal proceedings. And basically, that is what happened more or less in 2017, 2018, 19, that a number of Polish judges that tried to be loyal and obedient to the Constitution and to the EU law started to be subject of that kind of disciplinary cases. And that is why this disciplinary chamber became a controversial institution, not only because of its composition, but also because of its role in curtailing the judicial independence in Poland.
Is this a unique issue? Is Poland the only country which was criticized for its constitutional setting and not fulfilling the standards of rule of law?
Unfortunately, Poland is not the only country, is not the only EU member state that has different problems with the rule of law. And I would like to mention here one country that does not have that many problems with rule of law, but at least one case was not really positive in the context of, let's say, Polish-EU relations. I mean here, Germany. Because please note that in last years, German Constitutional Court has issued a very interesting judgment in the case Weiss. In this case, the German Constitutional Court said that the German Constitution is having primacy over EU law. Of course, the judgment is much more complicated, and we should know this whole saga of Solange I, Solange II, Maastricht-Urteil, or other judgments decided in the past by the German Constitutional Court. But I would say that issuing a judgment in Weiss case in this special moment when the primacy of the EU law is at stake and when there are a number of other countries questioning the primacy of the EU law was maybe not the best and the most fortunate moment in the history of the European and domestic constitutionalism. Why is it so? Because this judgment has been used by Polish authorities and by the Polish, as I said, politically subordinated Constitutional Court. It was used as an argument to undermine the credibility and to undermine the value of the EU Court of Justice jurisprudence. So please note that as a follow-up to different cases that were decided by both the Court of Justice of the EU as well as by the European Court of Human Rights, Polish authorities started immediately proceedings before the Polish Constitutional Court, basically referring to the same arguments as the German Constitutional Court. The difference between those cases is such that the German Constitutional Court, in my opinion, still acted in good faith, and as a result of the jurisprudence, but also some actions undertaken by the European Commission, the German state was able to get into some kind of a conclusion and into the resolution of this conflict concerning the relationship between the EU law and the German constitution. In the Polish context, we have all the time a clash. But another member state that should be subject of attention here is Hungary. Hungary is having a number of rule of law problems, and I remember well that when Viktor Orban took the power, one of the major reforms was about decreasing the retirement age for judges of common courts. But interestingly, at that time, when this case has been started, European Union and the Court of Justice of the European Union did not have sufficient instruments to deal with it. And there was one case initiated by a commission against Hungary that concerned this retirement age for judges, but this case was qualified as the case concerning discrimination due to age, not as a case endangering judicial independence, but as I would say, a typical case from the package of the EU anti-discrimination law. And please look that a couple of years later, we have a judgment of so-called Association of Portuguese Judges case, decided in February 2018. And this case is opening the gate for a completely new interpretation of the European Union law, because in this judgment, the Court of Justice said that an independence of judiciary in particular member states could be subject of verification by the EU Court of Justice because of the principle contained in Article 19 of the Treaty on European Union, which says that the European Union should guarantee the effective legal protection when it comes to the application of the EU law. But this effective legal protection means that you must have similar standards of judicial independence in different member states, because otherwise the whole legal system of the EU, which is based on the mutual recognition and mutual trust, would not work. And that was a breakthrough. So that is why those Polish cases could be decided on the basis of those basic principles concerning judicial independence. And that is why the EU Court of Justice gave a lot of preliminary ruling cases or infringement cases on the basis of this interpretation of Article 19 of the treaty and Article 47 of the EU Charter of Fundamental Rights. We know well that in Hungary there are also problems with the operation of judicial institutions. There was a famous case of Judge András Baka, who has been dismissed from the position of the President of the Supreme Court, and this judgment resulted in the famous Strasbourg judgment Baka against Hungary. We know about conflicts between the new President of Curia, so the institution that replaced the Supreme Court, in the context of judicial nominations. We know about conflicts between the President of the National Council of Judiciary, who is appointed by the President, and judges who are sitting in the National Council of Judiciary. And it seems to me that those Polish cases concerning judicial independence might provide an important standard for other member states but also for judges of other EU member states to start preliminary ruling procedures, but also they would be of enormous value in the context of any future problems with the rule of law, but also in the context of different countries that are going to join the European Union. We know that right now, as a follow-up to the Russian aggression on Ukraine, it is not only Ukraine, it is also Moldova. We are also looking into different Balkan countries that would like to join the European Union, and for sure their standards of judicial independence would be measured with the use of that benchmarks that were established in the jurisprudence of the Court of Justice, including specifically the judgment of 15th July 2021 concerning the disciplinary chamber of the Polish Supreme Court.
How judges reacted to the growing political influence in Poland, and how did they react in Hungary? What should judges do if they see that their judicial independence is threatened?
I think that Polish judges were extremely active in protesting against those judicial changes. But I would say that it would not happen without the support of the Polish civil society. And, you know, I have this privilege that I could observe changes in the Polish judiciary and in the Polish state starting from 2015 when I became the ombudsman, because my term started in September 2015, and all those changes affecting rule of law protection started more or less in November 2015, and then I was basically the whole my term was going along those changes in the judiciary. And I remember 2015, 2016, when the Polish Constitutional Court was under attack. At that time, the Polish civil society proved to be extremely powerful and vocal regarding those changes affecting the Constitutional Court. But interestingly, judges were not so involved at that time in protecting the Constitutional Court as such. Somehow there was this kind of a feeling that, you know, there are those changes affecting the Constitutional Court, but, you know, nobody would dare to attack the Polish judiciary. Polish judiciary would remain independent. It would be, you know, one bridge too far. And I was saying, you know, look at other countries, look also at Hungary, look at scenarios happening in different countries in the world, including Latin America. This process would not stop just with the Constitutional Court. It would include other organs of power, and it would be an attack on the basic principle of the separation of powers. And I was not mistaken. In 2017, those changes started to affect judiciary, and then judges started to be much more vocal and started to fight for their independence. But I think the breakthrough was July 2017, when the draft law on the Supreme Court has been proposed by the ruling party. It happened just after the visit of President Donald Trump in Poland. Somehow it seems to me that Polish authorities read this visit as a, let's say, kind of a political agreement that, you know, you can go forward with different changes affecting the operation of the state. But interestingly, Polish civil society, Polish citizens reacted very strongly, because in July 2017 they organized manifestations in more than 200 Polish cities. And those demonstrations were important not only to block, at least for a certain time, some changes in the judiciary, but they were extremely important to show to the Polish judges that they may rely on the civil society and that people take care about the judicial independence. Over the time, this power of protest was much smaller. So judges and citizens could not, especially citizens, were not so eager to participate in demonstrations. But starting from, I would say, 2018, civil society, together with judges, but also independent prosecutors, bar associations, started to make two things. One thing is solidarity actions with different members of judiciary and also prosecutor's office that are subject of those disciplinary or immunity proceedings. So basically with those judges who started to be intimidated, such key figures in the Polish judiciary like Judge Tuleja, Judge Żurek, Judge Juszczyszyn, Judge Gonciarek, and many others. Plus, the second action was a very well thought, very detailed, and long-term oriented strategic litigation of cases. So please note that starting from 2017, we see a number of preliminary questions addressed to the Court of Justice. We see a number of cases directed to the European Court of Human Rights, but we see also a pressure by both Polish civil society, but also international academia, a pressure on the European Commission to start infringement actions. So, for example, this case we are talking about was not only a result of, that, I don't know, Mrs. Jourova and Mr. Reinders and just sat, in the room and they said, okay, let's go to the Court of Justice with this case. There was a huge pressure on the Commission not to forget about Poland. There was a pressure to use all the possible legal instruments in order to stop the operation of the disciplinary chamber. And in my opinion, only because the Commission had this legitimacy coming from the Polish civil society, Polish opposition, intellectual leaders, a number of other stakeholders, it was easier for the European Commission to go forward with this case and to achieve this judgment of the Court of Justice of the EU. For sure, it is one of the counter-arguments presented by the ruling party or people that were close to the ruling elite. So they were saying, dear judges, why do you engage into politics? It is not your role. Your role should be just sit and adjudicate cases, and if you are questioning some of those legislative reforms, it means that you are violating your principles of judicial independence. But judges, as well as civil society, reacted to this in such a way. They said that, it is not just a question of reaction. It is our duty. It is our duty to speak against changes affecting judicial independence. Moreover, they started to say, we are not only judges of the particular EU member state, we are the EU judges. We are trained to use the EU law in an effective way. We are going to all those different trainings, to Academy of European Law in Trier, to trainings organized by European Law Institute, we have a lot of EU professors that are providing classes, lectures on the use of the preliminary references. We are using this preliminary reference procedure in some consumer cases, tax cases, environmental cases, asylum cases. So why we should not use this procedure right now to protect our independence? And I think it was quite clearly stated in the jurisprudence of the EU Court of Justice that it is a right of the judges to make a preliminary reference, that judges should not be punished in any way for making that kind of references. Please note that one of those changes introduced in meantime was so-called muzzle law. That was the law that was going to intimidate or that was going to stop judges in making that kind of preliminary references, or that was going to stop judges in verification of statutes of some judicial nominations made by the National Council of Judiciary in new composition. But I think the most important judgment concerning this was the case of Waldemar Żurek against Poland. That was a case decided on 16th June 2022. It was the European Court of Human Rights judgment, in which the court said that it is a duty of the judges to speak, especially if they perform some special functions in the judiciary. They are members of the National Council of Judiciary, spokespersons of judicial associations, because basically it is part of their job to protect rules of the judicial independence. So from this angle, I think it is also quite interesting to look at this. But I think that one of those, let's say, black sides of the whole story in Poland is that we shouldn't, that there were a number of people in Poland, including judges, that decided to go along the path proposed by the ruling party. So basically, they've made this opportunistic choice to become members of the National Council of Judiciary, to become members of those newly created chambers of the Supreme Court, who became disciplinary judges, who became presidents of courts, who accepted nominations from the National Council of Judiciary. So, and of course, in such a situation, this fight is much more difficult when there are some people who are simply accepting those new rules of the game. So those new rules of the game in which the judicial system is politically subordinated. They find all different kinds of personal or moral justifications for themselves to prove why they have made this choice. But from my point of view, that was a wrong choice. And I'm quite happy that that the Court of Justice of the European Union became a little bit like the quasi-constitutional court for Poland, and thanks to the EU Court of Justice, we could count on this proper evaluation and assessment of the judicial changes in Poland. And still, thanks to this, we may say that the Polish judiciary is not yet fully subordinated. It is still in this, I would say, fighting mode for its independence. And in the context of upcoming parliamentary elections in 2023, it is really an important element of the legal system to have the judiciary, which is not yet fully taken over by the ruling elite.
We heard some critics that the organization and functioning of the judiciary belong to the constitutional setting of a member state. They have been given a wide margin of appreciation, therefore they have the sovereignty to introduce reforms without the consent of other member states and the control of European institutions. What do international courts have to do with the constitutional setting of a member state?
It is one of the major arguments used in the discussion concerning judiciary in Poland, but also in some other EU member states, that it is not the power of the EU to interfere, that European Union is, and the European Court of Justice is acting ultra vires here by making that kind of strong involvement into the operation of the judiciary. The problem is that nobody questions whether in Poland we would have, for example, division of courts into common courts, administrative courts, into military courts, whether in the common court system we have courts that are labor court, family courts, civil courts, criminal courts, and so on, whether we have two-level system or three-level system, whether courts are situated in this region or in the other. Nobody questions this. I think it would be, of course, going too far if, for example, the European Union would start to say that, I don't know, in Warsaw you should have only one court and not three courts, or that you should amalgamate administrative courts and civil courts into one jurisdiction. That would go too far. And I think European Union is quite aware of this, and the Court of Justice also. But European Union, European Commission and the Court of Justice says all the time, whatever organization you adopt, this judiciary must fulfill some basic functions in order to be really a court and not just some kind of administrative judicial institution. So simply, it should be a court that fulfills criteria under Article 6 of the European Convention on Human Rights and under Article 47 of the EU Charter of Fundamental Rights, which means this institution, which is going to adjudicate cases, must be independent from executive power. This is the most fundamental issue. Independence from the executive power in the context of nominations, in the context of performance of tasks, in the context of assessment how those duties are performed, and in the context of any, I don't know, dismissals, disciplinary proceedings or immunity-related proceedings. Moreover, if there is too much influence of the executive power and the legislative power on the judiciary, it may create so-called chilling effect on the judiciary. So judges should not work under some kind of a fear, under some kind of a threat that if they adopt any decision that would be contrary to political expectations, they could be subject of any sanctions. And that is the only thing what the European Court of Human Rights, as well as the EU Court of Justice, is doing, saying we are checking the institutional design of the judicial system in EU member states just from this point of view, from the point of view of guarantees of judicial independence. And we really don't care whether you have your courts in this or the other city, or whether you have this 2, 3, 4-layer system of courts, or how you construe those courts. Whatever you do, still all those courts must fulfill basic principles of judicial independence, because otherwise you do not have a fair trial, and otherwise you cannot enjoy a status of a country that would be a rule of law country.
Professor Bodnar, thank you for this interview. I would also like to say thanks for the attention of our audience. I hope you enjoyed this episode and the series of 30 Years, 30 Cases. Follow us on LinkedIn and check out our website to learn more about training opportunities for legal professionals.